A federal courtroom fell completely silent. Not because a verdict had been read. Not because a sentence had been announced. But because a sitting federal judge had just done something almost no one alive has ever witnessed. He ordered the lead defense attorney of a former president of the United States to be physically removed from his courtroom by U.S. Marshals. No warning. No fine. No private reprimand. Just removal. This was not a routine procedural dispute. This was not heated legal argument. This was a moment that legal scholars are already describing as a rupture in the normal functioning of American justice. And it all unfolded in real time. On January 17, inside Judge Arthur Brennan's federal courtroom, something shattered, not just patience, but trust itself. When that trust collapsed, the judge reached for the most extreme tool available to him short of incarceration. He called the marshals. To understand why this moment matters, you need to understand something fundamental about federal courts. Federal judges do not eject attorneys lightly. They do not remove lead counsel because of personality clashes. They do not summon marshals over ordinary discovery fights. When it happens, it means the judge believes the integrity of the proceedings is under direct threat. And that is exactly what Judge Brennan said, without saying it explicitly. The moment that changed everything. According to reporters inside the courtroom, the atmosphere that morning was already different. This wasn't a standard hearing. This wasn't just another motion argument. 37 journalists from major outlets had packed the gallery. Courtroom sketch artists filled the side benches. Members of the public began lining up before dawn to secure one of the limited seats. Everyone sensed something was coming. Judge Brennan entered at approximately 10:23 a.m. Eastern Time. Observers described his demeanor as cold, controlled, deliberate. No small talk. No casual remarks. He sat, adjusted his papers, and began reading from a prepared statement. That alone was unusual. Federal judges rarely read prepared statements during routine pretrial hearings. When they do, it means the judge wants the record to be precise and permanent. For nearly 40 minutes, Brennan outlined what he described as a pattern. Not a mistake. Not confusion. A pattern. 7 separate instances where the defense team's representations to the court appeared to conflict with evidence obtained independently through subpoenas. As the judge spoke, reporters noted visible tension at the defense table. Papers were shuffled. Eye contact with the bench was avoided. Then the judge stopped reading. And everything changed. The question that triggered the collapse. Judge Brennan looked directly at Trump's lead defense attorney, Emil Bove III. His voice was calm. Almost deceptively so. Mr. Bove, the judge said, I am going to ask you a direct question. I expect a direct answer. The courtroom froze. Will your client comply with the January 31st document production deadline as currently ordered? A simple question. Yes or no? Bove paused. Your Honor, he began, we have filed a motion for reconsideration. That is not an answer, Brennan interrupted. Yes or no? Will your client comply with this court's order? This is where things crossed from tense into historic. Bove tried again, referencing pending motions, executive privilege claims, procedural objections. Each time, the judge cut him off. Yes or no? The exchange repeated itself. Once. Twice. 3 times. By the 6th refusal, the courtroom was completely silent. No whispers. No movement. Even veteran court reporters later said they had never experienced tension like this. On the 7th refusal, Judge Brennan stopped speaking. He set down his pen with deliberate precision. Then he looked up. The line that couldn't be uncrossed. I have given you 7 opportunities to answer a direct question, the judge said. His voice now carried across the entire courtroom. Your continued evasion leaves me no choice but to conclude that you are either unable or unwilling to engage with this court in good faith. The word unwilling hung in the air. Multiple reporters later described feeling physical tension, the kind that makes your chest tighten. Several U.S. Marshals near the rear door subtly shifted their stance. Then Judge Brennan said the words that detonated across the legal world. Under my authority, pursuant to the inherent powers of this court, I find you in contempt. A pause. I am ordering your immediate removal from these proceedings. For a brief moment, no one moved. Bove reportedly went pale. Your Honor, he said, I must object. Your objection is noted for the record, Brennan replied, already motioning toward the marshals. You have 60 seconds to gather your materials. This hearing is in recess for 15 minutes. The marshals stepped forward. Trump's lead defense attorney was escorted out of the courtroom. Why this was so unprecedented? To understand how extraordinary this was, you need context. Federal courts run on trust. Judges assume attorneys are telling the truth, not because lawyers are saints, but because the system collapses if they don't. Discovery disputes happen every day. Arguments happen every hour. but refusing to answer whether you will comply with a court order crosses into forbidden territory. As one former federal prosecutor put it, when you refuse to say yes or no to compliance, you've already answered the question. Legal analysts immediately recognized the significance. The ejection of lead counsel, not a junior associate, not a witness, but lead counsel in a case involving a former president, is almost unheard of. It signals that the judge believes the process itself is being abused. And that belief did not form overnight. Months of escalating friction. According to court filings, tensions in Judge Brennan's courtroom had been building for months. Prosecutors accused the defense of missed discovery deadlines, incomplete document production, late-night emergency filings, contradictory representations. The breaking point may have begun on December 4, when the defense filed emergency motions at 11:47 p.m., just minutes before a midnight deadline. Those filings claimed certain documents were unavailable. Weeks later, subpoenas to third parties suggested otherwise. That discrepancy landed directly on Judge Brennan's desk in the form of a sealed memorandum dated January 14. 3 days later, the courtroom exploded. 3 days before the courtroom erupted, something landed quietly on Judge Arthur Brennan's desk. No press release. No public docket entry. No advance warning. A sealed memorandum from the prosecution, dated January 14. At first glance, it looked procedural, another filing in an already crowded case. But this memo was different. It wasn't arguing law. It wasn't requesting relief. It was documenting contradictions. According to multiple sources familiar with its contents, the memo laid out a timeline that prosecutors believed demonstrated something far more serious than missed deadlines or sloppy filings. It suggested that the defense had told the court one thing, and that reality, confirmed through independent subpoenas, told another. This is the moment where routine litigation crosses into dangerous territory. Why sealed memos terrify defense teams? Sealed filings aren't unusual in federal court. They're used to protect sensitive information, national security material, or confidential witnesses. But when a prosecution submits a sealed memo accusing defense counsel of misrepresentation, it triggers alarm bells at the highest level. Because judges understand exactly what that implies. If prosecutors are wrong, they risk sanctions themselves. If they are right, the consequences are existential for the defense. According to reporting, the January 14 memo documented at least 4 separate instances where defense representations to the court conflicted with evidence obtained from third parties, entities not controlled by Trump or his legal team. That distinction matters. Courts expect advocacy. They do not tolerate deception. The document that didn't exist. At the center of the memo was one specific document, or more accurately, a set of communications. For weeks, the defense had maintained that these communications did not exist, or could not be located after a diligent search. That claim was made. In written filings. During hearings. In sworn representations to the court. Then prosecutors subpoenaed third parties. And the documents appeared. Fully intact. Time-stamped. Authenticated. According to sources who reviewed the material, the communications directly contradicted earlier defense assertions, not just on substance, but on existence itself. That distinction is critical. Arguing over interpretation is normal. Arguing over existence is not. Why this crossed a red line? Legal ethics draw a bright line between advocacy and misrepresentation. An attorney can argue a position aggressively. They can push interpretations. They can test legal boundaries. But they cannot tell a court something doesn't exist if it does. That's not strategy. That's a credibility collapse. As one former federal judge explained privately, once a judge believes an attorney is lying about facts, every single thing that attorney says becomes suspect. That appears to be exactly what happened here. Judge Brennan's private review. On the morning of January 17, before entering the courtroom, Judge Brennan reviewed the prosecution memo in chambers. Sources say the review didn't take long. Not because it was thin, but because the pattern was clear. For contradictions. Multiple filings. Independent verification. This wasn't a one-off error. It was a sequence. Judges are trained to give lawyers the benefit of the doubt. Honest mistakes happen. Miscommunications occur. But patterns are different. Patterns suggest intent. The decision before the hearing. By the time Judge Brennan walked into the courtroom, he had already reached a conclusion. Not about guilt. Not about the case's outcome. But about trust. And when trust is gone, judges act. That's why he read a prepared statement. That's why he outlined 7 instances. That's why he asked a question he already knew the answer to. He wasn't seeking information. He was testing whether the defense would finally acknowledge reality. They didn't. Why the yes or no question mattered so much. To outsiders, the judge's question might seem narrow. Will your client comply with the document production deadline? But legally, it was enormous. A yes would have acknowledged the court's authority, restored some measure of credibility, diffused the confrontation. A no would have triggered immediate consequences, exposed open defiance. The defense chose a third path, evasion. That's the worst option in federal court, because evasion signals contempt without the courage to say it out loud. The moment marshals knew. Multiple reporters later confirmed that U.S. Marshals in the courtroom recognized what was coming before the order was spoken. That's not coincidence. Marshals work these rooms every day. They understand judicial body language. When Judge Brennan set down his pen, the decision had already been made. The removal wasn't emotional. It wasn't impulsive. It was procedural and devastating. Why physical removal is rare. Contempt findings happen. Sanctions happen. Fines happen. Even brief detentions happen. But physical removal of lead counsel is almost unheard of. Why? Because it disrupts proceedings. It invites appeals. It creates headlines judges usually avoid. When a judge chooses this option, it means he believes the alternative, allowing the attorney to remain, is worse. In Judge Brennan's view, continuing with an attorney he could not trust would compromise the integrity of the case itself. Immediate aftershocks. Within minutes of the recess, phones lit up across the legal world. Defense attorneys in unrelated cases watched the feed in disbelief. Former prosecutors texted each other one-word reactions, unreal. Inside Trump's legal orbit, emergency calls were scheduled immediately. This wasn't just a setback. It was a warning. The impossible position of the remaining team. Trump's remaining attorneys now face a nearly impossible task. They must meet accelerated deadlines, rebuild credibility with a hostile bench, argue aggressively without triggering further sanctions, all while their client publicly attacks the judge. This is a nightmare scenario for any defense team. Because credibility, once lost, is rarely restored. Historical echoes, but with a twist. Legal historians immediately drew comparisons. Watergate, Iran-Contra, high-profile corruption cases. But there's a key difference. In those cases, judges eventually clashed with defendants. Here, the clash occurred before trial, during discovery, at the stage where courts demand maximum cooperation. That's why experts are calling this a watershed moment. Why other judges are watching. Federal judges don't operate in isolation. They read each other's rulings. They watch appellate outcomes. They notice patterns. If Judge Brennan's actions stand, or go unchallenged, it sends a signal. Obstruction has limits. Evasion has consequences. Power does not override process. Several judges, speaking anonymously, have admitted frustration with similar tactics in other cases, but hesitation to act as boldly. That hesitation may now be gone. The political fallout begins. Within hours, the story exploded beyond legal circles. Cable news. Social media. Political commentary. Pollsters immediately noted something troubling for Trump. Independent voters overwhelmingly support compliance with court orders, regardless of politics. Images matter. And the image of an attorney being escorted out by marshals is powerful and damaging. What comes next? Judge Brennan scheduled a follow-up hearing for January 24. That hearing will determine how the defense proceeds, whether additional sanctions are imposed, whether contempt findings expand. Appeals are expected.